Welcome to the side event of the United Nations Forum on Responsible Business and Human Rights, titled SLAPPs in Southeast Asia, Legal Frameworks to Protect Human Rights Defenders. I'm Dory from Inside PACT, supporting this webinar to make sure everything on the technical side runs well and to ensure you have a smooth experience. For this webinar, the chat is disabled, but please feel free to submit any questions to the Q&A window. After the panelists speak, there will also be a Q&A session. During that time, please send your questions to the Q&A window or even beforehand, which you can do by clicking the button on the bottom of your screen that says Q&A. The moderator will be looking at the questions submitted there. You can also upvote other questions that you would like to be answered, and the speakers and/or moderators will do their best to answer them during the session, time permitting. So thank you everyone for joining. Our panelists are very excited to be sharing their thoughts with you today, and we will start the session shortly. There are a few people coming in now. Okay, so actually I will now hand over to Betty Yolanda, the Asia Regional Manager at the Business and Human Rights Resource Center, so we can start the webinar.
Thanks, Dory. Good morning, everyone, and also good evening, depending on where you're joining us from. So welcome to the site sessions on strategic lawsuit against public participation in Southeast Asia, legal framework to protect human rights defenders. As Dory mentions, I'm Betty Yolanda, the Asia Regional Manager of the Business and Human Rights Resource Center, and I will be facilitating our discussion this morning. To lead us in discussion, we are pleased to have with us three distinguished speakers who have been very much involved in the subject of our discussion today, whether it's through research, advocacy, and litigation. So the first speaker, Ms. Golda Benjamin, she has been active in litigation and advocacy work since 2006, focusing on agrarian and land rights, trade and economic justice, food security, and workers' rights. She's a lawyer and a law professor in the Philippines, and she has worked for various national and international organizations and movements, both as a full-time member of the staff or as a consultant. Our second speaker, Ms. Sor Rattanamanee Polkla. So her career spans the past 19 years of public interest lawyering in Thailand, and she has been involved in many of its recent SLAPP cases. So after working for years as an independent public interest lawyer, in 2010, she co-founded with Prashant Singh the Community Resource Center, a non-governmental organization working with communities who face the impacts of development projects. Our third speaker, Mr. Antonio Gabriel La Viña. So Dean Antonio is an expert in Philippine, ASEAN, and international environmental law. He has worked for decades as a professor, scholar, senior government official, lead negotiator, and advocate on environment and climate justice, as well as biodiversity issues, indigenous people's rights, and access to justice. Before diving into the discussion, I will start with a few comments to set the scene around the topic. Across various sessions during the forum, we have heard how human rights defenders continue to be persecuted and often labeled as enemies by both governments and businesses in an attempt to delegitimize their work and activities. In Southeast Asia, judicial harassment appears to be the tactic of choice used by businesses to suppress the work of human rights defenders. While many of SLAPP's lawsuits were brought against environmental defenders, in recent years, we have seen an increase in the use of SLAPP to target a wide range of individuals and organizations acting in the public interest, such as labor rights defenders, journalists, whistleblowers, and also community leaders. At the Business and Human Rights Resource Center, we recorded about 290 attacks against human rights defenders in Southeast Asia between 2015 and 2019. 127 of these attacks were through judicial harassment, and 30 of these cases are considered SLAPPs. The vast majority of cases are brought based on libel or other defamation charges. In addition to the briefing note on SLAPPs in Southeast Asia that we are launching today, the Business and Human Rights Resource Center is currently undertaking a globally focused SLAPPs project that aims at highlighting the growing phenomenon of SLAPPs and producing a database of cases and a series of analysis and communications tools that will support the efforts of civil society groups as well as human rights defenders across the globe. So now let me turn to our first speaker, Golda Benjamin. So Golda, you will be presenting the results of the research done by the Business and Human Rights Resource Center. So what are the key findings and recommendations from this briefing note that you can share with us today? And also, are there good practices that can be replicated by other human rights defenders or advocates in other countries in Southeast Asia? You have 5 minutes.
Thank you, Betty, and good morning, everyone. This paper, we actually observe some worrying trends in SLAPPs in Southeast Asia. Number one, there's a propensity to combine both civil and criminal cases against human rights defenders, which exhaust the resources of human rights defenders and practically paralyze them in their work. We are also seeing that companies are asserting exorbitant damage claims, even up to as high as 3.3 million US dollars in a region where the average minimum wage is around $300 a month. Of course, there's the very common phenomenon of using anti-terrorism laws, the Computer Crimes Act, financial crimes legislation. And we're also seeing a worrying trend where the targets have gone beyond the usual community leaders and have also included NGO workers, lawyers, and even expert witnesses being brought to court and sued. And finally, there's also the worrying trend of targeting women human rights defenders who are often unsupported by any other organization and are just protesting really on their own in defense of their communities. So our paper on SLAPPs in Southeast Asia is really, our aim was to highlight some of the more progressive rulings from courts in Thailand, Malaysia, and Indonesia. And the link to this paper is now on our chat window. And I'd like to take this opportunity also to thank the lawyers who also contributed to this paper. And these are Edmund Vong, Ryan Vong Junying, Eko Riyadi, Sahid Hadi, Salvani Kaujuliakam, and of course, Sor, who joins us in the panel today. Betty, one thing is very clear. Some courts around the region and in the world have decided in favor of human rights defenders. And this should be a recognition that courts and prosecutors have a great role to play in protecting human rights defenders. By doing this study, we hope to encourage governments to provide stronger, clearer, and more effective legal frameworks to sustain court decisions like this one. Because the cases that we have studied, they're not enough. And that's why we're seeing a rising trend in using the court's power to actually restrict the exercise of the fundamental rights to speak and to assemble and to express our opinions on about especially the negative effects of business operations. So just allow me to walk everyone through important rulings coming out from the courts, and we hope that governments can use these rulings as the starting point to reform SLAPPs legislation. First ruling. A court said that activists have contributed much to the well-being of society and that transparency and accountability are better served when activists are allowed to make statements against the company's operations. And this is very powerful because it recognizes two values: transparency on the part of businesses and also the need for accountability. Second one, I mentioned a while ago that there are additional victims of SLAPPs, and this includes also journalists. And one court out of Malaysia did rule that journalists have the right and obligation to report matters of public interest, even if this include negative information about the companies. And this is very promising because just a few days ago, another court in Thailand actually also ruled that if you're reporting on matters of public interest, then you should not be made liable for defamation. The third ruling is very close to my heart, and because the ruling of the court is very similar to the Philippine Constitution. And in this from Thailand, a court said that the right to protest is part and parcel of the right to assert the need to protect the environment. It's progressive, and this should be the norm rather than the exception in all these SLAPPs cases. And in Indonesia also, a court said that persons who fight for the right to a good and healthy environment are immune from suit. Not just that the suit will be dismissed, but that these people are immune from suit. And another one from Indonesia, a court very clearly said that expert witnesses should also be immune, especially for their testimony given, and the court uses this testimony to actually convict a particular person. This is particularly important because we're seeing a trend where expert witnesses whose testimony become vital to a judgment of conviction end up facing another suit right after the criminal case is concluded and wrapped up. And finally, of course, this is very important. A court in Malaysia said that a private expression of a negative opinion on the services of a particular business is not defamatory, even when these opinions are released in public, provided that the writer or the speaker did not consent or did not know that these kinds of opinions, for example, posted on a private email or a private Facebook group or chat group, if these are inadvertently released in public, then that person should also not be held liable. So as my first intervention, I'd like to emphasize that these cases still are not the norm in many of the courts around the world, and especially in Southeast Asia. And we're hoping that these cases will be a starting point for more judicial and legislative reform in relation to SLAPPs against human rights defenders. Thank you, Betty.
Thank you, Golda. So as we all know, winning is not necessarily the goal of SLAPP lawsuits. It is more about exploiting the financial and power imbalances between the plaintiff as well as the defendant. So Sor, as a human rights defender and public interest lawyer who had defended against SLAPP lawsuits, what are the key challenges that you face, and how do you amplify existing efforts to strengthen the protections of human rights defenders in Thailand?
Thank you, Betty. First of all, I want to say that when we talk about the SLAPP case, it's not only the defamation cases, but it's also the form of the judicial harassment that the business using any kind of lawsuit to against the public participation with the, in my experience, with the community who protest the project of business. Then when they do, they use, yes, defamation case, either the criminal case or civil case, but it's also about the kind of trespassing, kind of the public assembly law, because in Thailand we have a public assembly law, and also about the extortion, saying that they have been forced to do something, so it's like that. Then a lot of criminal cases have been used by the business to stop the public participation from the community, as well as the human rights defender, that is the activist and other also. And then what the most important for this? First of all, I think the business and also either the government interest, the public interest have been protected. It's not by the government, but it will be with the community who are facing with the land grabbing, national resources grabbing as well. Then they have a right to protect the right by doing the public participation. Then if the government and business understand about the public participation, the case as a SLAPP will not be. But the thing is that because they don't understand about this right, that is why they try to stop the voice of the people. Thai government try to make the so-called anti-SLAPP law under the criminal procedure, the article 161/1, to say that if any private case, the private sector brought the case to the court, and if that case is related to the public participation, is related to the public interest, then and it's like a misusing the court. then court can drop the case without trial. But what we got the experience, the judge never used this article since it already have a 1 year apply for this law. But we did not find any cases the judge using this for the for this article. Then it seems like it's nothing change in Thailand. We have national action plan, and in the national action plan saying that okay, it will develop for the anti-SLAPP law. We also want to see the anti-SLAPP law as the one law, as a specific law to protect the people. And in that, it's not only changing one or two articles in the criminal procedure law, but it needs to have it proper because it needs to show that what is the SLAPP, what is the human rights defender that we have to protect, and how we should apply this law for any cases. I learned from the Philippines that Philippines has a SLAPP law, but it seems like I'm using for environmental cases. That I'm not really sure that I am right or wrong. But this is a chance for government and business sector to see how they can develop for the law, and also to understand about the role of the business in Thailand. When the SLAPP come, it's not bring by the business sector, but it's also bring by the government sector, because of the government when they want to promote the business project, then they also try to use this SLAPP lawsuit and making understanding of the sector business, government, and also the stakeholder of the judicial system, such as police, prosecutor, and judge, to understand about this kind of SLAPP lawsuit. Then it will develop and also helpful for the case. I think I can also, another one that I would like to say now is also the system of complaint, because of whenever the government did not try to open for the complaint and protect the complainant. This is also very difficult for the people who would like to defend for their right or defend for the public interest. There are a lot of cases that the people, human rights defender, have been charged because of they just send the complaint, or they just post the complaint letter in the social media. Then this is also very difficult. Then anti-SLAPP law, it should be cover all of this. Thank you.
Thanks, Sor. So before I continue with the follow-up questions, I'd like to invite our third speaker, Din Antonio. So speaking about legal frameworks and also legislations, in 3 countries in Southeast Asia, namely in Thailand, the Philippines, and then as well as Indonesia, there are pieces of legislations that guard against lawsuits that may restrict the work of human rights defenders. So Din Antonio, we know that the Supreme Court rules of procedure for environmental cases in the Philippines, which took effect in April 2010, contain explicit anti-SLAPP protections for environment-related cases. So it's good also for us who are here in the discussions to know why these rules of procedures were adopted in the first place, and also to what extent human rights defenders have been using these rules in their defense against SLAPP. Over to you, Din Antonio.
Okay, thank you. Yes, I think 10 years since the Philippine Environmental Rule of Procedure was adopted. I'm very fortunate to have been the co-chair of the Supreme Court committee that developed and then drafted the rules before it went to the revision of rules committee of the Supreme Court, and then finally adopted by the Philippine Supreme Court. The background of the rule is actually very straightforward. For a while now, the Philippines have been seeing the experience of a surge of environmental cases, and people felt that there was a need to codify the jurisprudence with very good cases by the Supreme Court, over five, maybe 10 of them over the last 30 years, that were favorable to the environment. And it was time to codify them into the rules. Go to the next slide, please. And so we did it out of a felt need. The idea was, you have so many cases that are going on now. At the time, this was 2010. But you have to use the old rules, rules that were not applicable to environmental cases. And so let's look at what's unique about environmental cases and draft good rules that would protect the environment and give access to environmental justice. So that was really the motivation. We had a very good Chief Justice at the time, Chief Justice Puno, who really wanted to come up with very strong remedies that people could use in environmental cases. So we did go around the country, and we had a big summit where we invited all the different sectors, but particularly the environmental defenders, to suggest what they would want in that rules of court. And there were several things that were there. It's not my topic, so I will not go through them. We actually developed two new writs, writ of kalikasan or writ of nature, which you could use to stop activities that threaten the environment. And we also developed what's called a writ of continuing mandamus, which is about ordering the government to implement its own law. And we had the SLAPP rule, and I'll talk about that in a while. But as you can see in the slide, the environmental rules of court, the environmental rule of procedure that we had the following objectives: to protect and advance the constitutional right of the people to a balanced and healthful ecology, to provide a simplified, speedy, and inexpensive procedure for the enforcement of environmental rights and duties recognized under the Constitution, existing laws, rules, and regulations, and international agreements. And then to introduce and adopt innovative and best practices, ensuring the effective enforcement of remedies and redress for violation of environmental laws. And then finally, to enable the courts to monitor and exact compliance with orders and judgments in environmental cases. The SLAPP rule falls under letter A, letter B, and letter C, because we know that these lawsuits directed against environmental defenders was used to intimidate us, so that we would not file cases or advocate for the environment, and therefore that would affect the constitutional right of the people to a balanced and healthful ecology. Second, even most of these SLAPP cases, we would win that. They would not go further, but they're harassment cases. The essence is that they're harassment cases. They become very expensive to defend ourselves from. So because of that, we push very hard for the SLAPP rule, so that we will have simplified, speedy, and expensive procedure to deal with SLAPP cases. And then it's an innovation, as you know, as an innovation necessary for enforcement of remedies, because it's a way to defeat harassment. Next provision, please. So what does the SLAPP rule say? I mean, first I have to say it defines it defines the rules of court. The rule of procedure defines SLAPP very clearly. and I'll read it. It's in the PowerPoint also. Strategic lawsuit against public participation refers to an action, whether civil, criminal, administrative, brought against any person, institution, or any government agency or local government unit or its officials and employees with the intent to harass, vex, exert undue pressure, or stifle any legal recourse that such person, institution, or government person has taken or may take in the enforcement of environmental laws, protection of the environment, or assertion of environmental rights. It's very straightforward. But any lawsuit that's brought against you to harass you, to stop you from advocating environmental rights is a SLAPP. Is a SLAPP. Is something that is covered under this rule, which is Rule 19 of the next slide, please. Which is Rule 19 of the rule of procedure. Um, can you go to the next slide? So it has several very simple provisions. If a SLAPP is filed against a person, and this is criminal SLAPP, then the accused may file a motion to dismiss on the ground that the criminal action is a SLAPP. And right away there's a hearing. And the best evidence there is actually to show that you are advocating for something and the person that filed this lawsuit against you is the adversary there. And you have to only prove it by substantial evidence. You don't have to prove it by reasonable doubt, by preponderance of evidence. You can prove it by substantial evidence that your action is an enforcement of environmental law. It's a legitimate action. While the party filing the action shall prove by preponderance of evidence that the action is not a SLAPP. So we made sure that the environmental defender has an upper hand. He only has to show substantial evidence, any evidence to show that his action is environmental in nature and that this lawsuit is intended to prevent that. And then the accuser must prove by preponderance of evidence, even at that stage, even at the stage of the that this is not a SLAPP. It's not intended to inhibit or intimidate public participation. Next, please. And then the court shall do it summarily and grant the motion if, in fact, he finds that that's the purpose, that this is a SLAPP. And then if the motion is denied because it's a legitimate criminal lawsuit, then the court shall immediately proceed with the arraignment of the accused. We've been very successful in this because we don't find criminal cases. Before this, you had actually lots of criminal cases that were filed. But because, this rule, the beauty of this rule is that the stocks are against the accuser, against the one who files the SLAPP. And so therefore it's a deterrent against that. It's a protection of environmental NGOs, protection of environmental lawyers, protection also of environmental officials. So that's also strategic. We added environmental officials because the truth is that I used to be Undersecretary of Environment of the Philippines way back in the 1990s. And every time we enforce, we always get criminal lawsuits against private parties to stop us from enforcing environmental law. So we had that experience, and so we made sure to put that in. So the ones protected are environmental activists, environmental NGOs, communities, environmental lawyers and advocates, and of course environmental officials. Human rights. We don't have an equivalent of this in human rights, but I think it's easy to do. The thing is, we haven't revised the criminal procedure for a while now, so I think it's easy to once that procedure is revised again, then I think we can also put this in for human rights cases. But I think another way of putting this in is to get the Commission on Human Rights to adopt a SLAPP rule. Sort of like the Commission on Human Rights in the Philippines cannot rule on human rights cases because they're not a judicial body. But they are a recommendatory body and they can intervene in courts with leave of court, and they can put up a rule that says that if there's a SLAPP against human rights defenders, they can actually come in and intervene to support and to provide cover for human rights defenders. And since right now we have a very good Commission on Human Rights, I think they would be open to have those rules, a resolution that would allow the Commission on Human Rights for intervention, pending the amendment of the criminal procedure rules, or having a human rights SLAPP rule itself that the Supreme Court can come in. I mean, can adopt. The other gap is civil cases, SLAPP that are intended, that are civil cases, SLAPP that are civil cases, because this rule that we have for environment is only for environmental, for criminal procedure, because we didn't have a lot of experience in civil cases, but that might also be necessary at some point. The difference, of course, in civil cases, they don't file civil cases because they have to file filing fees for damages if they ask for things like that. So most of the SLAPPs are actually criminal in nature. I end there. Thank you.
Thank you, Dean Antonio. So actually, we have an immediate question from someone who is watching the live stream on YouTube. So the question is, we have some rules to dismiss SLAPP cases in Thailand, but prosecutors do not really dismiss the cases as per the rules. So did you in the Philippines train prosecutors? But before answering that, let me invite someone from UNDP. So UNDP has been providing technical support to the Thai government, both in the drafting of the National Action Plan on Business and Human Rights. So as you know, last year, Thailand launched the National Action Plan on Business and Human Rights, and Thailand became the first Asian countries that launched that National Action Plan. And also from the previous discussions that we had during the forum, one of the representatives from the Thai government also mentions about the idea and also the plan on drafting an anti-SLAPP legislation. So the question is now, we know that human rights defenders is one of the priority areas that is included in the National Action Plan. But regardless of how well formulated a policy is, it is still useless if it is not effectively implemented. So a representative from UNDP office, Ms. Tarini Suraforanon, the project manager on business and human rights of the UNDP country office, Thailand. So she would like to share some insights on the implementations of the human rights defender provisions in the Thailand National Action Plan, and also to see to what extent it can provide better protections for human rights defenders. But also, I think it's also good for us to get some comments from Sor after the comments from Ms. Tarini, who was actively involved in the NAP process, just to get her sense whether is it enough, the provisions on the human rights defenders in the National Action Plan to push for better protections of human rights defenders. So I'll give the floor to Ms. Tarini first, and then to Sor.
Okay. Thank you so much, Betty, for your kind introductions. And hi, everyone. Here, I just would like to give you my quick reflections and the work that we are doing at UNDP Thailand Country Office in relation to SLAPP and human rights defenders. As the intergovernmental organizations, UNDP is aware of the situations of human rights defenders and also challenges that they face in Thailand. So we have monitors closely, and this year we will be working with the Royal Thai government in order to enhance the current practice related to the promotions and protections of the human rights defender and their work in the countries. So in relation to this, we are collaborating with the Ministry of Justice to carry out two studies in these years. One about the anti-SLAPP measures and laws, and the second one will be about the protections of human rights defenders. So in these two studies will be elaborate specifically in the context of Thailand, and the result of this study will not be addressing only the existing gaps in terms of law and regulations, but will be also addressing the gaps of the business practice, which we consider is one of the main contributing factors to challenges facing the human rights defender in our countries. Even though we are still in the process of developing this study, we aim that the consultative and inclusive approach will be applied throughout the process of this study, since the beginning of drafting the TOR, data collections, until validations of the preliminary findings. So I would take this opportunity to reach out to everyone who are watching here, which I'm sure that you are our main stakeholders who are working on the SLAPPs and issues related to human rights defenders, to provide us the feedback, input, or even the recommendations on the element that we should include in our study. So feel free to reach out to us, and vice versa, we will reach out to you for consultations. In addition to this, in this year, we also will have a more direct engagement with the private sector through conducting a series of trainings related to human rights due diligence, which is a process for the business to identify, prevent, and mitigate the human rights risks, not only in their own operations, but also in their supply chains. So the issue related human rights defender would be one of the key topics that we going to integrate in the HRDD curriculum to train the private sector to build the awareness and the understanding about how they can protect and cause the risks to human rights defenders. So just my quick update for now. Thank you.
Thank you, Tarini. I would like to ask Sor just to give like 2-minute comments on whether you see the national action plan, there's a chance for it to be effectively implemented in Thailand.
Thank you, Betty. I would like to say that actually National Action Plan is no any enforcement. It's just only policy that is in Thailand. Then National Action Plan need to do implementation and also apply to have any kind of like a regulation or law for that. Then this is the first thing. And in the National Action Plan, as I say already, there is the issue of human rights defender, and that is also include about the SLAPP lawsuit that they would like to develop as an anti-SLAPP lawsuit. But the problem of National Action Plan right now is that we don't have enough engagement with the implementation on the National Action Plan in the practice. Then it would be better if we have enough engagement, like open for the public participation to develop any kind of issue, any law, any regulation in the National Action Plan, especially with the anti-SLAPP law. Because the problem is people not understand what is the SLAPP. And very important is if the person who have to use the law to enforce, they need to understand what is the SLAPP. I actually working on the SLAPP cases, many cases, and when we go to the court, and also when we talk with the police or public prosecutor, when I talk about the SLAPP, they don't understand. When I say that it is a SLAPP case, they should drop the case because of it's nothing. It should be dropped in the end of the case. Why not drop it in the first step to avoid a lot of capacity that we have to spend, right? But they don't understand. They say that law saying like this, law saying that this is the trespassing, law saying that this is the defamation. Even under the Thai law on the defamation criminal law, it's already said that if somebody talking about a public interest matter, they would not be charged or they would not be prosecuted in the case. That is mean they can drop the case in the first time, but no, the judge also still ask for the trial, and then finally The same with our friend case with the Sutari on the case of the defamation recently. Finally, it's also the judge saying that it's because of what the message that interview in the video is the truth, is not the facts. That is why they dismiss the case. But how long that they spend the time and all the expenses for the case? It takes so long, right? 2 years, or fastest is 1 year. But anyhow, it's nothing. Then when we talk about the National Action Plan, when we talk about the anti-SLAPP law, it seems that people who are working on this have to understand first what is the SLAPP. The SLAPP is not only defamation case. We find a lot. We found a lot of cases. Is not only the defamation that they use. Now they use the Computer Crime Act as well. They use the trespassing. What I said already. And lastly, I would like to say that the other one, because of right now, when we make the law, it's not easy. It's not like within 1 year we will get the new law. Then in the meantime, making understanding of the people, especially with the judicial stakeholder, to understand about the SLAPP. It also can prevent the SLAPP lawsuit come to the court, and also to protect the people. And in another way, we need to use the counter case to stop the SLAPP. What I mean is, if somebody try to use the SLAPP lawsuit against the human rights defender, against the people, and finally they won the case, they also have a right to counter the case. And this is also another prevention for the case on the SLAPP as well. Thank you.
Thank you, Sor. So let's go back to Dean Antonio. So the question directed to you was, did you in the Philippines train prosecutors to ensure that the rules are being used in SLAPP cases?
Yes, actually, that's a good thing. Right after the rule was adopted in 2010, in the next 2 years, judges, prosecutors, and environmental lawyers were actually trained on, given seminars on what the new rules, the different provisions of the new rule was. And so what's remarkable about it, there's nothing controversial about the SLAPP rule. People thought, in fact, it was the right thing to do. You could not really argue against it. And so that's why I'm saying for us, it became this is a law that actually has not been used, because there have been, less cases, very, very few cases now, criminal cases on environmental defenders. But we have an upshot of cases against human rights defenders. So that's the one, and that's because human rights defenders are tagged as communists. So that many human rights defenders are also being charged for being rebels or communists, etc. So that's why it's very urgent to have a similar rule for human rights.
Thank you, Dean Antonio. I know that we have received many questions specifically directed to you. So instead of you immediately responding to these questions, maybe you could look at the questions in the Q&A.
I look at it, yeah.
Yeah, and then you can type the answer. So I just now want to go to Golda Benjamin. So from your experience working and also engaging with business actors, how should business respond to criticisms and protests without resorting to SLAPPs?
Thank you, Betty. We've really had some good experience with businesses. Number one, businesses should adopt a non-retaliation, no SLAPPs policy. And that might sound very ideal to some of the participants here, but it's actually a real ongoing and rising trend. In fact, I'd be very happy to share sample policies of businesses around the world who have taken this particular stance. And it's very important for businesses to publicize their anti-SLAPPs, non-retaliation policies, because it is a commitment to human rights. There's a lot of commitment to labor, a lot of commitment to women economic empowerment and equality. And it's about time that companies will come out with these kinds of statements. Also, companies, there has to be a change in paradigm. Spend the enormous amount that you would rather spend on litigation and use it to develop effective company grievance mechanisms. There are a lot of guidelines. I'd be very happy to share some guidelines for companies to develop these kinds of mechanisms. So there are many options, Betty, for businesses, and SLAPPs shouldn't be one of those options.
Thanks, Golda. One interesting point raised and also emphasized by Dean Antonio was about the role of national human rights institution. So we know that also in Southeast Asia, there are national human rights institutions with A status, but in practice, they don't really implement their mandate. So Sor, going back to you from your experience in litigating SLAPP cases, how do you see national human rights institution play a role in ensuring the protections of human rights defenders? Sor, you can unmute and you have 2 minutes, please.
Yes. Actually, this is also very difficult to say about the National Human Rights Commission of Thailand, because the thing is that understanding is a matter right now when we talk about the human rights defender as well, or also a SLAPP, because you know, there is the case against the complainant who submit the complaint to national to NHRC, saying that this is a fake information and also this is a defame to the company. Then they don't have any protection role to protect the components. This is a problem. It's also because of the National Human Rights Commission also need to understand about the human right. When we talk about the human right, we like the labor right. In the case of the chicken farm, is because of the labor complain that they did not have enough to rest. They have been deduct the wage. They have been hold the passport, something like that. And this is also the violation of the labor. But in the term of using the human rights violation, the NHRCT just use the term as this is abuse the labor law. It look similar, but it's a different. When you talk about abuse the law, sometimes people not think that this is a human right that have been protected. Then understanding and also making the role to protect the components is also very important for the NHRC in every country. I don't know in other countries they have, but in Thailand we don't have any kind of protection for the component. You have to understand that the component sometimes in the letter they say something that maybe it's just only a feeling fear and feeling things, then some message maybe is right or wrong. But you have to think about this is the letter of the people who have been violated, who are the victim. Then you have to protect the victim, not just like open the chance for others to counter their complaint, and then after that use that the complaint letter to file the case against the victim. This is very important role for the National Human Rights Commission, and I did not see that kind of protection. Even I found that sometimes National Human Rights Commission sending that letter to the people have been complained to the company and also to the government agency. Then everyone have seen that letter. This is also not good for the protection, because they will be target, right? They can be harassed when the people who found that, oh, this is the person who against them, something like that. Then this is very important role for the National Human Rights Commission and even for the law to think about how they can protect the people who make the complaint. Thank you.
Thank you, Sor. We are running out of time. So maybe I would like to invite all speakers just to give a maximum 2-minute closing remarks, especially focusing on what kind of recommendations that we can give both to governments as well as businesses. So maybe I'll start with Golda and then Dean Antonio and then Sor.
Thank you, Betty. For governments, I have three recommendations for now. I have many, but I'll discuss three for now. Number one, the laws should recognize and protect human rights defenders and their work. There's even a question from the participants that sometimes the definition of the law is very difficult, and it's either very broad or very narrow, that many human rights defenders end up not benefiting from the provision. So there's a need to look at the language of the law. Second, of course, there's a need to prohibit SLAPPs. And of course, there's an ongoing campaign to actually decriminalize defamation and libel. And as Sor very, very correctly pointed out, that SLAPPs also involve all other cases beyond libel and defamation. So countries that are looking at SLAPP should look at that also and protect other types of human rights defenders. And that businesses should also be made liable if they file these cases. So I can actually share to the participants a new paper that's coming out next week that outlines some of the policy options being taken by various states in the United States and also around the world. So there's a term like cost shifting, burden shifting, when it comes to after the court or the prosecutor finds that a SLAPP's case does exist. And there's also, finally, this has been an advocacy of mine, that government should consider a SLAPP's defense fund. And even funders should think about increasing the funds for human rights defenders. We know that litigation funding has been slashed so severely in the past years. The support for human rights defenders has only grown 1% in the last 6 years. So government, international organizations like the UN should try and consider putting up more resources also in defense of human rights defenders. Thank you, Betty.
Thanks, Golda. Over to you, Dean Antonio. You need to unmute first. Hello, Dean Antonio. You're still muted. Can you unmute first?
Am I okay now?
Yes.
Yeah. I echo Golda's recommendations, so I won't repeat that. But I'll start with I do want to build on the last thing that you said, the importance of a legal defense fund. That's also where we have successes in the environmental field, because we have a long history of environmental defense funds. I actually right now chair a foundation called Forest Foundation of the Philippines, and we always set aside money for environmental defense, including for SLAPP cases. So that's really important, and in particular that is available for those that are in the frontiers. I just saw right now actually in Palawan, which is one of the biggest areas of the most diverse biodiversity rich areas of the Philippines, that environmental enforcers were actually arrested by police. So very important to have those human rights defense funds that are available, particularly for those that are working in the marginalized areas. And then I would just add the importance of education. I think we talked about business, about corporations. This is the round table is about that. That's very, very important. But within that, I suggest that there's also a reach out to stockholders, to shareholders, so that especially those shareholders that are institutional, pension funds, church, Christian or other church investors, that they always raise human rights concerns in stockholder meetings, in shareholder meetings, in the same way that they're also raising environmental and climate concerns now in many of those meetings. But we have to educate shareholders and stockholders for that, so that they can influence the behavior of companies. And then the third group I would like to reach out for SLAPP education is actually the media, so that in fact are filed against human rights defenders, the media is able to call that out, and that's not a legitimate attack. When you're being tagged as a communist because you're a human rights defender or charged a communist, the media should be able to come in right away and say, they're only doing that because this person or this lawyer or this group is defending the human rights of someone or their own human rights. And so media is very important that they understand when a SLAPP is a SLAPP and not a legitimate case. Thank you.
Thank you, Dean Antonio. So, Sor, 2 minutes, please.
Yes, I agree with both Golda and Antonio, and I would like to add only 2 points. First point is about the we need to open for the participation, for the public participation in the properly way, for the either the implementation on the anti-SLAPP law and also for the national action plan or any kind of doing to understanding for the SLAPP or human rights defender. That is the one. And this is to make them understand that the human rights defender is not enemy of the government or of the business. They have to understand that the human rights defender or the community in the area, they just want to make everything good for everyone. When I say everyone, it's not only for the community, it's also for the government, it's also for the business. If they use this strategy as a assessment for the business, then it will make the business also in the stable for their business as well, and also it also can protect the community and also environment. And lastly, for the country who have NHRC, National Human Rights Commission, this is also important role for the National Human Rights Commission to understand that the human rights defender or the community who want to protect their right, or the people who want to protect their right, they have a right to be protected as well by the National Human Rights Commission and also by the government. Then they have to understand that these people, not the troublemaker, they are the people who want to make the country better and more want to make the community better. Thank you.
Thank you, Sor. I just before I close the discussions, I just also want to reiterate what Sor has said, that we need to change the narrative about human rights defenders. We need to make sure that governments and businesses do not see them as enemies, but instead they are the key actors to development. So we only have like 1 minute left. So I just want to take this opportunity on behalf of the organizer to thank all speakers, to Dean Antonio, to Golda, to Sor, and also to Tarini for all your valuable contribution to the discussion. So thank you so much. So I hope we can continue this important discussion in the near future.
Thank you. Thank you very much.
Thank you very much. Bye.